All right, let's dive into a real-world legal battle over HOA transparency that perfectly captures the critical concept of the burden of proof. Welcome to today's explainer, where we're using the original source documents to break down exactly how a seemingly simple neighborhood disagreement turns into a formal, full-blown legal showdown.
We've all been there, right? You write that check to the HOA every month and kind of wonder, where exactly is this money going? That super relatable frustration is actually the hook for today's explainer. We're looking at a legal dispute over missing money that didn't just end in an argument over a neighborhood fence, it escalated all the way in front of an administrative law judge. When the person managing your community's money won't open the books, what actually happens when you try to force their hand?
And you know what's really wild about this specific case? The scale. You're probably picturing this massive, sprawling suburban neighborhood with hundreds of identical houses. Nope. This fierce bureaucratic showdown, it all went down in a tiny community in Tempe, Arizona called 10th Avenue Missions. We're talking exactly 6 patio homes. 6! It just goes to show, legal drama scales down just as easily as it scales up.
So, here's our docket for today. We're going to look at the great HOA dispute itself, break down the law of the land, and unpack the burden of proof. Then, we'll weigh the conflicting claims and testimony, reveal the final verdict, and watch as the appeal clock starts.
Part 1. The Great HOA Dispute. Let's get right into the background of this clash between resident Carol Portonova and the 10th Avenue Missions HOA.
The whole thing kicked off in 3 pretty distinct steps. First, the HOA actually sued Portonova and her husband and won a judgment against them. Second, the HOA collected the money to satisfy that judgment. But then, step 3 hits. Portonova basically says, okay, I paid, but I want a strict accounting of exactly where that money went. She wanted to see the receipts, especially for the attorney fees. I mean, she was so serious about this, she paid a hefty $550 filing fee to the Arizona Department of Fire, Building, and Life Safety just to force them to give her those answers.
Moving on to Part 2. The Law of the Land.
To understand how you win or lose a case like this, we have to look at the specific rules of the game in Arizona. The absolutely crucial statute here is ARS Section 33-1805A. This is the state law that guarantees an HOA member's right to reasonably examine association records. Portonova built her entire case around the claim that the HOA explicitly violated this specific law by withholding those accounting records from her. Now, translating the legalese into plain English, this statute sets up some very strict boundaries. HOAs have to make records reasonably available. They absolutely cannot charge you just for looking at the materials. Once you ask, they've got exactly 10 business days to make it happen. Oh, and if you want physical paper copies, they cap that at a maximum of 15 cents per page. It's a really clear framework, designed from the ground up to guarantee neighborhood transparency.
All right, Part 3, the burden of proof. This is arguably the single most critical legal concept in this entire administrative hearing.
Because, look, in the eyes of the law, it honestly doesn't matter what actually happened. It only matters what you can prove. The judge actually cited Black's Law dictionary for this, specifically looking at the phrase preponderance of the evidence. It means having evidence that's of greater weight or just more convincing. Just picture the classic scales of justice here. You don't need absolute, beyond a reasonable doubt certainty like you would in a criminal trial. Preponderance of the evidence just means you have to prove your version of events is more probable than the other side's. You literally just have to tip the scale slightly in your favor.
Which brings us to Part 4, conflicting claims and testimony. Let's look at the actual evidence presented and see how this devolved into a total he said, she said courtroom drama. This clash right here perfectly illustrates the fatal flaw in Portonova's case. On one hand, you've got Portonova claiming she verbally asked for the records during a November 2011 HOA meeting, and then followed up with a formal letter on May 3, 2012. Actually, adding to the confusion, her official petition originally claimed the violation happened way back in June 2011. But on the other side, Respondent Mario Capriati Jr., representing the HOA, gets up under oath and testifies that no request was ever made at that November meeting, and he sure never received any letter in May. And here's the kicker. Portonova lacked hard documented proof. She had no certified mail receipts, no written meeting minutes to back her up, nothing.
Part 5. The final verdict. So what happens when you weigh a complete lack of a paper trail against completely conflicting testimonies?
Administrative Law Judge Louis D. Kowal made his official ruling on October 2, 2012, and he stated it pretty plainly. Because Portonova completely failed to tip those scales of justice with concrete proof, the petition was dismissed. The exact wording was, petitioner failed to establish by a preponderance of the evidence that a request was made. No action required of respondent. This is such a massive cautionary tale for all of us. Knowing your rights is great, but keeping the actual receipts to prove you exercise them, that's the whole ballgame.
Finally, Part 6, the appeal clock starts. Because even after the judge bangs the gavel, the administrative bureaucracy keeps marching on. This kicks off a very strict procedural timeline. On October 2nd, the judge rules. The very next day, October 3rd, the decision gets electronically bounced over to the Department of Fire, Building, and Life Safety. They basically have until November 7th to accept, reject, or modify it. Well, they took no action at all. So on November 13th, 2012, Director Cliff J. Vannell steps in and officially certifies the decision as final. It really shows how slowly but surely the wheels of justice turn. And that November 13th date, that's what officially started the ticking clock for any potential appeal to the Superior Court.
Which brings us to our final takeaway for today's explainer. Next time you submit a formal request to your HOA, or really anyone for that matter, are you going to make absolutely sure you get a certified receipt? Transparency laws definitely exist to protect you, but as we just saw, without an airtight paper trail, those protections are essentially invisible when you step into a court of law. So, are you keeping the records you need to truly protect yourself? Definitely something to think about the next time you drop an important letter in the mail. Thanks for hanging out with me for this explainer, and we'll see you next time.